Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast and everyone in between. Welcome to our last I-9 webinar of 2023. Today we're going to talk about what has happened with the Form I-9, a little bit of a recap and some end of the year tips for you to deal with your I-9s. So with that, let's get started. We always have a legal disclaimer, right? Because we're attorneys. So what I'm talking to you about today does not constitute legal advice. It's for informational purposes only. If you have specific legal questions or issues that you need to have addressed, please reach out to your counsel, or we would be happy to help out if we're your counsel or you're looking for counsel. So I'm Kimberley Robidoux. I'm a partner with WR Immigration. I'm based in San Diego, California. I am a vice chair of our American Immigration Lawyers Association's Verification and Documentation Committee. So I guess you could say I kind of geek out on I-9s and compliance. And it's a good part of my practice for, I guess, over 20 years now, which is hard to believe. So I'm happy to talk with you about I-9s. And here at WR Immigration, we journey forward with our clients and colleagues in order to help with anything immigration related. We are, a firm of 90 offices globally with a global immigration practice, and we like to stay creative, innovative, and connected. So welcome to WR Immigration's webinar today. All right, what are we going to do? This morning/afternoon, we're going to talk about internal I-9 audits, COVID-19 cleanup, as well as the new Form I-9 when employers need to know the alternative procedure, and then just some FAQs, which is I will look at the Q&A. So if you have any questions, please feel free to pop those into the Q&A section. And I will either try to address them as we go along or at the end or towards the end of the webinar, just depending on how I can toggle everything. So with that, we'll get started. Okay, internal I-9 audits. It's end of the year cleanup, or for those of you who are planning right now, it'll be start of the year cleanup if you want to do this beginning in January or early 2024. So why do you want to conduct an internal I-9 audit? There are a few reasons. One of the main reasons that I always recommend doing an internal audit is to discover issues that may be fixable prior to ICE, Immigration and Customs Enforcement, coming knocking on your door, right? So there are issues on the form that you can fix internally. Some items are not fixable, but you want to get ahead of ICE if you can. You can also, doing an internal I-9, conduct the audit and corrections on your own time schedule, as opposed to 3 days that ICE might give you, or if you get a notice of technical or procedural failures, you might have 10 days to correct some of the fixable items. If you do an internal audit, you may also reduce potential fines by thousands of dollars. And that's by correcting some of the issues that can be corrected. You also want to catch up on any overlooked work authorization re-verifications and/or determine if you have any unauthorized workers. And by unauthorized workers, I'm primarily, thinking about those individuals who had work authorization to begin with. And if their work authorization had expired and you forgot or overlooked re-verifying their work authorization, they may not have continuing work authorization and are unable to continue to work for the company. So in that particular situation, you want to make sure that you don't have such individuals on the payroll if you were to be audited by ICE. And then the fifth reason out of our top 5 of why to conduct is, you might consider engaging an attorney to assist versus a consultant. As using an attorney may keep issues attorney-client privileged. And so that's one of the things with, working with an internal audit where you're working closely with your attorney is to, clean up those things that you may miss because I-9 is super complex. Even though we're back to a one-page form, it has gotten really complex recently. Okay, I-9 penalties, right? This is one of the reasons where you can take a risk assessment to determine, are we going to do an internal audit now? Is it something that we can let slide? Do we have a good handle on how our I-9s are? Because one of the things that will happen if ICE does an internal or ICE does an audit is that if those items that cannot be corrected are caught by ICE, you can be fined. So the I-9 penalties are primarily civil penalties. Criminal penalties may apply where there's a pattern or practice of violations. The company could also be debarred from government contracts if there is a situation where there may be unauthorized workers that were found by ICE during an investigation. There could also be a court order requiring the payment of back pay to an individual who's been discriminated against. That might be, in the course of an ICE investigation, an individual had some issues, and that might be brought to the attention of Department of Justice, or just different situations that could happen, which could lead to a hefty civil fine or having to pay back pay. And then there might also be a court order requiring the employer to hire the individual discriminated against. Now, the rate of possible penalties is regularly increased. The government issues this information in the Federal Register, typically the beginning of the year, the calendar year. So the I-9 paperwork violations in 2023 are between $272 and $2,701 for the first offense for substantive violations or uncorrected technical errors. And then you have additional fines for recruiting, referral, and rehiring violations, where the penalties go from $676 to $5,404 for the first offense for knowingly employing unauthorized workers. Right? For subsequent offenses, obviously those fines are going to go up. I know this is a little bit old, but to give you some context, in 2019, fiscal year 2019, ICE conducted 5,981 I-9 inspections and reached $14.3 million in fines. It's been a little bit less since then because we had a decrease in ICE audits and investigations throughout COVID. But what does this really mean for you as an employer, right? We see that there's a fine of $272 up to $2,700, but what does it really look like in real dollars? You can have a company with fewer than 30 employees that may have errors on 50% or more of their I-9s, and you'll be facing about $50,000 or more in fines. Why does it get that high so fast? Because what happens is ICE uses a matrix, and if the I-9s, more than 50% of the I-9s have violations on them, you're going to typically be fined at the higher end of the range. So all those I-9s that have violations, even though it might seem like a pretty simple violation, your fine for that I-9 might be $2,300 or $2,700, and you multiply that by the number of I-9s that you have, and that's how you get to over $50,000 pretty quickly. So it really is a situation where employers are being penalized in some instances for doing the same mistake over and over again. So you're consistent in the mistakes, and that's what leads to a higher fine, especially if those mistakes are not correctable, right? So just keep that in mind, that it isn't always $272 per I-9. We tend to see them well over $2,000 per I-9 because, like I said, if you have a mistake, it tends to be carried over most or all of the I-9s. And then we have criminal penalties. So the company really is not going to get hit with criminal penalties unless they're doing something that's pretty egregious, where you kind of knowingly are hiring individuals that don't have work authorization, and that is your practice to do so. So in those situations, an individual can actually be imprisoned for up to 6 months for pattern and practice of I-9 violations. Okay, what about internal I-9 audits? Now you know what penalties can be assessed. So taking a look at it, risk analysis. Are you going to do an I-9 audit at the end of the year? Is it something you might consider at the beginning of the year, or maybe not even do? You might risk it. But if you want to an internal I-9, and this is either on your own internally or with assistance from a consultant who's knowledgeable in I-9s, or with an attorney who's knowledgeable in I-9s, when you're looking at your I-9, you want to just, determine the purpose of the internal I-9 audit. Is it to clean up? Is it to get everything in compliance? Is it to avoid the Form I-9? Kind of just have a general sense of the reason for doing it. You also want to determine the scope of your I-9 audit. Again, because you're not being audited by the government, you can make the determination of whether or not you're going to do a random sampling of I-9s. So out of 3,000 I-9s, you might do a 10% sampling, so you can get a gauge of what the issues might be. You also want to make sure that you have some type of communication with employees. If you're going to be in that situation where you're going to need employees to make corrections on the Form I-9, we don't want employees to get scared that they're in trouble, or for rumors to get around the organization that, that are of concern to employees. So the communication with employees is always key. The other thing is you want to avoid discrimination. I know this sounds pretty like, duh, that's something that you definitely want to do. And I apologize for being blunt with that, but discrimination can be, unintentional. So you just want to understand what you're doing with an I-9 audit, and not, pick on a certain class of people or a group of people or a section of employees. You need to be consistent. And definitely no retaliation against individuals for something that they have discovered is right, or they're sticking up for something that is not being done correctly. And then you want to create a process for correcting the errors or omissions found on the Forms I-9. And that process, can be a step-by-step process if you're, working with a couple of people within the organization, or you might have one person who's going to be tackling the review of a subset of I-9. So just have your process, as well as guidelines for how to make the corrections to errors. That, is the worst thing, is if you correct incorrectly. So you just want to make sure that you have everything set out so you understand what you're going to be doing going forward. And those who are on your task force, so to speak, if there's going to be a group of people, they're all on the same page and doing everything consistently. Right. The next step is you're going to gather all forms I-9 that are to be audited, whether they're paper or electronic. You want to ensure first that there's a Form I-9 for every employee on payroll. So you're going to compare your I-9s to your current payroll to make sure that you don't have any missing employees for which I-9s have not been completed. You want to obtain Forms I-9 for current employees, right? If there is no I-9 for them on file. Some things do get overlooked, or if there's paper I-9s, sometimes things get lost. So you want to make sure that you are on task for having a Form I-9 for every employee. And then you want to audit the forms for current employees section by section. And what I mean by that is having your process, right? It's always best to start with the top of the form and go to the bottom of the form. So you want to make sure as well that only employees are making corrections to section 1. You can determine what corrections need to be made and then guide the employee on what they need to correct in section 1. And then only company representatives can make corrections to sections 2 and 3, or under the new version of the Form I-9, section 3 has been replaced by supplement B. You want to correct the errors and document that those errors have been corrected. The government doesn't like it when things are backdated or they don't know when a correction took place, and it can actually be a ding against you in an audit. So you always want to initial and date corrections. And in an electronic I-9 program, there should be an audit trail that will recognize and point out those corrections and who made them, right? For section 1, the employee, and section 2 and 3, the employer. And then determine when Forms I-9 can be for terminated employees may be purged. When you want to make sure that you can get rid of the I-9s that can be purged so that you don't have those on hand that can be, reviewed by ICE during an audit and potentially increase your fines. So when can you purge Forms I-9, right? So it's 3 years after the date of hire or 1 year after the date of termination, whichever is later. So we have a couple of examples here, right? If you hire someone in March of 2020, they leave a little over a year later, you're going to have to retain that until March of 2023. If they're hired and leave 3 years later, you're going to have to retain until 2024. So always write out your formula. And we have a little handy sheet on the next slide here that employers will attach to, if they have paper I-9s, each paper I-9, some electronic software programs might actually have a retention calculator attached to it. So just, make sure that you are, doing the calculation, the formula, using the formula in order to purge the I-9s that no longer need to be retained. Remember, you always, always, always must have an I-9 on file for an active employee. The retention rules only apply to terminated employees. So you want to be careful, make sure you're not getting rid of I-9s for active employees. They always have to have an I-9 on file. So those are our retention rules that hopefully they can help you. Now, corrections with I-9 compliance, right? You're going to make sure that you're correcting what you can correct. If a form was completed untimely, meaning the individual did not complete Section 1 until the 3rd day of employment, as opposed to on day 1, that can't be corrected. But if there are no other errors on the Form I-9, that error of timeliness will essentially not be an error after 5 years under the statute of limitations. So that's one of the reasons why, if there's a timeliness error, you still want to make sure that you are making the corrections on any other errors of the Form I-9 that can be corrected. Never ever delete, white out, or black out. Government doesn't like that. Because they don't know what happened, who did what's under the blackout or the whiteout. So don't do that, and don't ever backdate. And by backdate, we also are referring to situations where a Form I-9 might be completed where the current version of the Form I-9 is being used, but it should have been completed later. And so we might have a situation where there's a current version of the Form I-9, but it's dated at an earlier date. The government really catches onto that fairly quickly. So you want to make sure that you are not backdating the form in any manner. All right, COVID-19 cleanup. Is it too late for reinspection? One of the things that we're going through right here is our timeline, right? Can't believe it's been 3.5 years already since March 20th, 2020, when the government put COVID-19 flexibilities into place. Those ran until July 31st of 2023, just this past summer. On August 1st of 2023, the new Form I-9 was introduced and became effective on August 1st. At the end of August, so August 30th, the reinspection period for COVID-19 flexibilities ended. Another key date is October 31st was the last day that the October 21st, 2019 version could be used. And that's the Form I-9. And then effective November 1st, only the new version of the Form I-9, which is dated August 1st, 2023, may be used for purposes of completing the employment eligibility verification process. Okay, so what were the COVID-19 flexibilities? Just to refresh everybody's memories. So this allowed for remote or virtual review of employees' identity and work authorized documents in limited circumstances between March 20th, 2020 and July 31st of 2023. So initially the flexibility was only if there was no company representative located at the work site. And then about a year later, in April 2021, Department of Homeland Security tweaked this flexibility and allowed employers to use the remote or virtual review if the employee was working remotely due to COVID-19. Not remote just because that was kind of the new way of working, but if someone was remote because of COVID-19. A written policy was required in order to document what the remote or virtual review was for those remote employees. And then the government said, you must conduct a reinspection by August 30th of 2023 after the flexibilities had ended July 31st. So again, what was due by August 30th, 2023? What was due is a physical inspection of the identity and work authorization documents that had been reviewed virtually, or an employer was able to utilize the optional alternative procedure to review the identity and work authorization documents for those employees whose I-9s were completed virtually within that COVID-19 flexibility period of time. So one thing to note is that reinspection via physical inspection or alternate procedure is only if the I-9 documents were not previously inspected in person. So some companies are actually able to complete the Form I-9 with a physical inspection, either directly with a company representative or the use of an authorized representative. So for those Forms I-9 where there were eyeballs that were actually looking at the documents from the employee physically in the same space as the employee, then those did not need to be re-inspected. It's only if the I-9 was completed where an employer was reviewing the documents through some kind of virtual process. Okay, so we're definitely well past August 30th. Is it too late to do re-inspection if you have not yet done re-inspection? Actually, it's not too late. It's better to do it now than to not do it, because ICE will fine for not doing the re-inspection. And actually, the Department of Homeland Security specifically stated that late re-inspections were better than no re-inspection. So specifically, at the end of July, they stated the following: if an employer is otherwise compliant with the law and regulation and has followed the COVID-19 flexibility guidance, then U.S. Immigration and Customs Enforcement will generally not focus its limited enforcement resources on Form I-9 verification violations for failing to complete physical document examination by August 30th of 2023, particularly where the employer can show that it has taken timely steps to complete physical document examination within a reasonable period of time. If you haven't started now, is that taking timely steps? Maybe, maybe not. There's always an argument that an attorney might be able to make to show, for whatever reason, the re-inspection started late. So if you haven't started re-inspection now, there's still a recommendation to do so. One of the questions that we had received was from employers that had completed a virtual review of the identity and work authorization document by doing some type of video meeting with their employee, as opposed to having the employee mailing copies of the documents or fax them or email them or upload them securely. If there was an actual video meeting where the employee presented their documents as well as sent in copies of the documents, there was a question about, hey, this is almost identical to the alternative procedure, so do we need to actually do re-inspection? And Department of Homeland Security, specifically USCIS, say, yes, even if your process seemed to mirror the new virtual alternative procedure, you still need to do a re-inspection. And the reason why is because the government has to close out that COVID-19 flexibility period and close it out with a re-inspection. And then the new process for alternative procedure can begin as of August 1st, right? So it was very intentional by the government that they required this reinspection process because they didn't want everything to just flow from COVID-19 and say, oh, we're just going to move forward. They want to make sure that everything is closed out from the COVID-19 flexibilities. So that's one of the key things for employers to keep in mind. So with that, what are we talking about for this alternative procedure, right? This is something that's brand new that came into effect on August 1st. So the alternative procedure is, something that the government finally admitted that they were willing to allow an employer to review documents virtually. And, as horrible as COVID-19 was and the quarantining and everything that happened during that period of time, one of the things that did come out of it had a positive impact is that the government saw that employers could really, do something with this virtual review of documents to complete the Form I-9 process. So they created and implemented a new alternative procedure and this is for new hires. So effective August 1st of 2023, an employer can use this alternative procedure, which allows for the virtual review of identity and work authorization documents for purposes of completing the Form I-9 if the employer is a qualified employer. And what's a qualified employer? A qualified employer means that the employer is enrolled in and in good standing with E-Verify. Further, the government has defined E-Verify good standing, meaning that the employer is enrolled in E-Verify with respect to all hiring sites that use the alternative procedure to remotely examine documents, that the employer is using E-Verify to confirm the eligibility of newly hired employees in the U.S., and that the employer complies with all other requirements of the E-Verify program. So unless you are in a situation where you are enrolled in E-Verify, but you're not creating cases for new employees, or you're ignoring the TNCs, you're probably in good standing. What we are saying is that employers will typically know if they're not in good standing if they're contacted by E-Verify with a notice of intent to terminate. So if an employer has received a notice of intent to terminate, then that's a good indication that you're no longer in good standing with E-Verify, or you're on your way out of good standing with E-Verify and need to take some corrective measures. So keep that in mind with respect to good standing. It's this definition that's going to be slightly evolving as we move forward to see how ICE and the government kind of use this through audits. Right. So now that we have defined that only a qualified employer can participate in the alternative procedure, what exactly is the alternative procedure? Well, for the alternative procedure to be used, an employer has to be enrolled at every hiring site in the U.S. that allows virtual verification under the alternative procedure. That means that if you are going to use the alternative procedure at location 1, 2, and 3, but not 4 and 5, then locations 1, 2, and 3 have to, where they're considered a hiring site, they have to be enrolled in E-Verify, right? They have to be acknowledged in the E-Verify system. As an employer, you have to offer the alternative procedure consistently to all employees at a hiring site or to none. So what does that mean, right? It means that you're not going to discriminate against who you're going to complete the I-9s virtually for and those who you're not. So if you have a situation where you have all remote employees are considered under a hiring site and you're going to do the virtual alternative procedure for those employees, but do the in-person review of the I-9 identity and work authorization documents for those who physically come into the work site, then that's creating a process that's defined and in the eyes of the government fair, right? You're not saying, oh, if your name begins last name begins with an A, we're going to allow you to do virtual and everybody else has to do in person. You have to be very consistent about the sites where either everyone at a site is going to be virtual alternative procedure or everyone at the site is going to be physical inspection. A little caveat there. If you have an individual who does not want to do a virtual inspection, a virtual meeting, I'm sorry, not inspection, but a virtual meeting, then you may want to address that situation to understand why it is that they don't want to do a virtual review of the documents with a video meeting, and then make that accommodation to do a physical review by either a physical review of the documents in person with the individual and a company representative, or potentially using the authorized representative program, whereby the individual might not be within driving distance of a physical worksite location for the organization. So you might be utilizing an authorized representative, which is anyone, typically over the age of 18, who can review the documents physically in person with the employee to ensure that their eligibility, that their identity and work authorization documents are valid, real, and not fraudulent or fake. And the other thing with the alternative procedure is that the individuals who are completing the E-Verify case performance are going to have to review an E-Verify tutorial that includes information about fraud awareness and anti-discrimination training. So if you're already a user in E-Verify, you may be prompted the next time that you go in to the system to complete this training. So that's something to keep in mind. The training is out there already. It's been in place for a couple of months on the E-Verify platform. So told you about the general overview of the alternative procedure, but really, what is the process, right? What are we doing? The whole goal around this is to allow an individual to present their identity and work authorization documents virtually without having to have a physical in-person inspection of the documents. So the government has set forth specific guidelines and process for completing the virtual verification process of the individual's documents. So first, the employee is going to have to send to you securely copies of the list A, B, or C documents that are going to be utilized for the I-9 process. The employee has to send you copies of the front and the back of each document that they're presenting. We recommend that you request front and back copies of all documents, even if the back of the document is blank. And I always say, well, how do we know the back of the document is blank if we don't have a copy of it? But that also helps you with just making it an easier process, as opposed to telling an employee, we need the front of every document and the back of it only if it has something on it, if it's not blank. So just make sure to request copies of both sides of the documents. It'll make your life easier. Second, the employer has to examine copies of the documentation to ensure that that what's being presented is reasonable and appears to be genuine. So you're going to look at the documents that come through to you, either by a secure email, or they're uploaded, or they're mailed in, or faxed, whatever the process is. And then as the employer, you're going to conduct a live video interaction with the employee, right? So you're going to schedule, however you're going to do that with an appointment process, but you're going to schedule a time to do the video meeting with the employee. And that video meeting can be through any process, right? It can be through FaceTime, Microsoft Teams, Zoom, WebEx, whatever process you have, that will be acceptable. The government has not limited it to specific types of video meetings. During that meeting, the individual is going to have to present to you the documents that they sent to you as copies, right? If the individual, from the time that they sent you the documents as copies until you have the video meeting. If they've lost that document, they now need to present a different document. So before you can continue with that video meeting, the individual has to send you the copies. You review the copies, and then you have the video meeting where the individual puts their passport or their EAD card or whatever document it is that they're presenting, so that you can review it and compare it to the copies that you previously received. Then what you're going to do when you complete section 2 of the Form I-9, on the new version of the Form I-9, there's a box that allows you to check off that you utilize the alternative procedure to examine the documentation. You now need to maintain copies of those documents that were presented for the purpose of completing the I-9 in the video meeting. And then you're going to complete the I-9 as you normally would and create the E-Verify case, again, as normal. So this is the box that I mentioned, right? In section 2 of the Form I-9, there's a little box in the additional information field that says check here if you used an alternative procedure. So that's what you're going to check off. Either if you have a paper I-9, you'll check it off physically, or with an electronic I-9 program, there will be a spot where you can check that off on as you proceed through the Form I-9 electronically. So one of the things that I also wanted to talk about briefly is E-Verify, right? Because the alternative I-9 procedure, alternative procedure that allows for virtual review of documents for the I-9 process, requires that an employer be enrolled in E-Verify, specifically at those hiring sites. So what are some of the reasons to enroll in E-Verify or not enroll in E-Verify? So we're going to talk about those. So E-Verify in general is a federal web-based system that allows employers to confirm the eligibility of their employer's work authorization in the United States, right? Employers, this is really key, is that even if you're enrolled in E-Verify and you complete the E-Verify process, you have to complete an I-9 for every employee. So the system usually works where you complete the I-9, and then once the I-9 is completed, the E-Verify case is completed and submitted to the government. So some of the pros, right, of using E-Verify. Some state and federal contract or government contractors are actually required to use E-Verify. This will be specified in the contract. So even as a subcontractor, you might be required to be enrolled in E-Verify for this particular project. So you have to be careful about making sure that you check what is required via the contract. E-Verify is currently voluntary for most employers, but there are some states that do have mandatory E-Verify enrollment and use of the E-Verify system. North Carolina and Arizona, for instance. So that's one of the reasons that you would want to enroll in E-Verify if you're mandated to do so. And then another thing to think about, if you hire foreign nationals, individuals that are coming specifically straight out of a U.S. college or university, have that F1 status and are working with optional practical training, they may be eligible for an additional 24 months of authorized practical training if their degree is in a STEM field. And as an employer, you're enrolled in E-Verify. So that was one of the carrots that ICE used with implementing this additional 24-month STEM OPT was, hey, you can get this 24-month STEM OPT if the company is enrolled in E-Verify. So that's helpful to some employers if you are hiring the best and brightest and you want to retain them beyond that 12-month OPT, especially now that we're seeing less than 20% chance of selection in the H-1B cap lottery. So being able to use the STEM OPT for additional work authorization has been very helpful to many employers. And it's also helpful to many employees. Those who are still in F status are typically exempt from FICA and Medicaid withholding, and that helps them out, keep a little bit more money from their paycheck. The other thing is, I know we haven't seen these a lot lately, the Social Security no match letters, but there's also letters that come out or documents, notification that come out from health insurance. If somebody's Social Security number doesn't match what's in the particular system, using E-Verify, you may catch those in advance because E-Verify is going to let you know if there's work authorization attached to that individual by the government reviewing the Social Security database and the Department of Homeland Security's database for work eligibility. These letters tend to be prior knowledge that the individual did not have work authorization. So E-Verify tends to help in that respect from not continuing with the process of onboarding or continuing to employ somebody who might not have work authorization. The other thing is that there might be a tentative non-confirmation, but most situations where there is a tentative non-confirmation, those can get cleared up pretty quickly, is what we've seen with most employers. They're definitely not as common as they used to be. And then the last pro that I have right now is that as of August 1st, employers that are qualified employers, meaning enrolled in E-Verify, can now use this alternative procedure of virtually reviewing the documents for I-9 process. All right, what are some of the cons or the negatives to enrolling in E-Verify? One of the things is that it does allow Social Security Administration and Department of Homeland Security to audit the data that's submitted. E-Verify has an account compliance section that reviews the data approximately every 30 days to determine if there are what we call normal statistical parameters. So they might be reviewing situations to see if an employer is engaging in a discriminatory contact. And how does that play out? Well, if you have a high number of individuals that are permanent residents and they present their permanent resident card for purposes of completing the Form I-9, that might be seen as a pattern by the government of potentially asking an individual who's a permanent resident to provide a specific document, i.e. the green card, to complete the Form I-9. And permanent residents are required to keep that Form I-9 on their persons at all times. So it tends to be the document that they're more readily to produce for an I-9 process. But the government does track the information. They look for patterns and practices of potential issues, which they can, through their memoranda of understanding, share with other agencies, such as Immigration and Customs Enforcement or the Department of Justice's Immigrant Employee Rights section. And speaking of which, under our Biden administration, the Justice Department's Immigrant Employee Rights section, which oversees any type of discrimination with respect to document abuse, citizenship discrimination, or national origin discrimination in the I-9 process. They will investigate that. ICE doesn't investigate those particular issues, but IER may investigate that and lead to hefty fines. So that's something to consider. IER has been actually very active in the last couple of years, specifically with looking at recruitment, how things are noted with employers' recruitment online in their advertisement to see if there's any type of potential discrimination. And then the other thing is that enrolling in E-Verify is not going to decrease the chance of an I-9 audit or a fine, but it can help out in some limited instances, but it isn't going to be that situation where because you're enrolled in E-Verify, you're not going to be audited by ICE or your fine's going to be lower. All right, some of the other things is that even though E-Verify is a free system, it does cost the company in terms of administrative costs, right? How many employees do you need that are going to be entering the data into E-Verify? That could become costly for an employer. It just really depends. on the size of the company. There are also situations where erroneous non-confirmations of work authorization may not be caught if there's identity theft, or they could be caught. So there's that issue there that comes up every now and then. It isn't a big issue, but it is something that does happen. Also, the E-Verify system has had maintenance issues where they're periodically offline. So in those situations, you want to make sure that you keep track of when the government system comes back online so that you can enter the E-Verify case and not forget to enter it. And then something that we didn't really have to worry about much in the past, but in the last few years, we're almost at that constant threat of a government shutdown. When we have had a government shutdown, E-Verify system is shut down. It goes offline. So during a government shutdown, a company is not able to enroll cases in E-Verify. So once the shutdown has ended and E-Verify is back, then all those new hires, new cases need to be entered into E-Verify. It actually has become a situation where E-Verify does account for that in their drop down, or the reason that E-Verify case is being created and completed late because of a government shutdown. So that could add additional work to your team once the shutdown, has been ended and you have to enter everything. All right, so E-Verify. To E-Verify or not to E-Verify, we tend to recommend it in most cases. It tends to be beneficial. However, keep in mind it is very much a company decision. Take a look at all of the pros and cons from each individual company's perspective to determine if it is the right thing for the company to do, if it's going to be helpful with respect to compliance and I-9s, of course. And one thing to note is that our firm has registered and is an active participant in E-Verify. All right, we're just going to look at the new Form I-9, right? This is what became effective on August 1st. So we're just going to look through kind of what it looks like. So this new Form I-9, it replaced the October 21st, 2019 version. It has to be used as of November 1st. And just keep in mind that there is a Spanish version of the Form I-9, but it can only be used by employers that are located in Puerto Rico. One of the things that is huge for those of you who are I-9 geeks like me is that the Form I-9 has now gone back to 1 page. It used to be 2. The instructions have been reduced from 15 to 8 pages. Even though the Form I-9 has been reduced to 1 page, that preparer translator section has now been moved to a supplement A, which does not need to be completed unless there is a preparer translator. Section 3 of the old I-9 is now supplement B, and that only needs to be completed if there's a rehire, re-verification, or a name change. The wording has changed a little bit. So rather than using the term alien, the government is now using the term non-citizen, kind of like that. It was kind of weird to refer to foreign nationals as aliens. Another thing that's happened is that the fields are smaller. If you're using the paper I-9 with an electronic I-9 system, you're not going to notice that the fields are smaller. One of the big things, I'm so happy that this happened, is that NA does not need to be included in those fields, such as other names used, email address, etc. So the old Form I-9 said that if you're leaving a field blank, you can't leave it blank. You have to put NA in it. That no longer is the case. We also now have a new alternative procedure box for the virtual verification. And then the list of acceptable documents, however, is still not as comprehensive as we would like it to be. So I'm showing the very top of the Form I-9 because it makes it clear that employers are liable for failing to comply with the requirements for completing this form. And also this anti-discrimination notice, right? All employees can choose which acceptable documentation to present for Form I-9 purposes. Employers can't ask employees for documentation to verify information in Section 1 or specify which acceptable documentation an employee must present for the completion of the Form I-9. In treating individuals differently based on their citizenship, immigration status, or national origin may be illegal. This is where Department of Justice's Immigrant and Employee Rights Division comes into play. So just quickly, we're going to go through the new version of the Form I-9. Make sure that over in the lower left-hand corner, it says edition, August 1st, 2023. Section 1 is condensed, right? We have the 4 boxes where an individual checks off what status they are. And then we have the USCIS A number, I-94 emission number, or foreign passport have been kind of squeezed in there before they were, a very large portion of it. So that's changed in Section 1. And then in Section 2, it looks very similar to the old Section 2. And now we have the alternative procedure box in the additional information field, as you can see here. And then the next thing that we have is our Supplement A and Supplement B, which we'll just present those a little bit so you can see what they look like. And then our list of acceptable documents, otherwise known as LOAD. This is the new edition, right? The list of acceptable documents has been revamped a little bit, where it highlights and has a link to the automatic extensions of EADs. We'll go to the next slide, please. So you can see here that there's a link to those sections, as well as a link to I-9 Central, where you can get all the updated information about the acceptable documents for I-9 purposes. Okay, this is Supplement A, which I mentioned before. This is solely if there's a preparer or translator for the employee completing Section 1. And you can see that this can actually be used multiple times for the same employee if you're doing some type of re-verification or edits. And then we now have our Supplement B, which replaces Section 3. Again, this is for rehire or re-verification, or if there's a name change. If there's a name change, you can update Supplement B at the time of the name change, or if you need to do re-verification at a later time, you would also update the name change at that point in time as well. Okay, some things to remember, resources for I-9 and E-Verify compliance. You have the E-Verify website, I-9 Central, the M274 Handbook for Employers, and our WR Immigration team. One thing to note with the M274 Handbook for Employers, it's a constantly changing document. The government is always updating it. So we recommend reviewing it whenever you have questions about documents that are being presented or on a particular process, as opposed to printing it out and using a print version, because the information in the M274 does get updated pretty often lately. So I'm just going to see what we have in our Q&A. One of the questions is to have someone remotely view the required document. Can it be someone in their household, i.e. a spouse or roommate, as long as they are over 18 years of age? And the answer to that is yes, that is acceptable. It's whatever the company would like to do in terms of an authorized representative. As a company, you can limit authorized representatives to people outside of your household, or you can leave it open to anyone in your household as long as they're 18 years of age. There are some caveats, specifically in California, where there are situations where a notary cannot complete the Form I-9. They're not notarizing it, but in some situations, they might not even be able to complete the Form I-9 under our California laws. So be careful about that. And let's see. So in California, must the authorized representative be a bonded immigration consultant? Yes, if they are receiving compensation for completing the Form I-9. And so we have some information about that on our WR Immigration blog. And if you would like additional information on that, feel free to reach out to us, send me an email or our team an email, and we can send you more information about the use of an authorized representative. Let's see, one last question here. So working at a company where the I-9s were saved to a file and there are no original copies. Should I print the I-9s and put them in a binder even though it is not the original copy? And do I attach a note why the original copy doesn't exist? So generally speaking, these are hard copies of the Forms I-9. I do recommend printing them and putting them in a binder, making sure that you have them stored safely. But one of the things is also to create a memo to the file that explains what happened in terms of how you're going to fix this going forward, because there are no originals. That's something that you really want to talk to Immigration Counsel on, because you do need to have original Forms I-9. So that might mean having every employee, active employee, complete a new Form I-9. So how you go about that process, how it's communicated to employees, et cetera, really needs to be discussed with counsel to make sure that you are doing the process completely and fairly, thoroughly, kind of accounting for any kind of communication that needs to be made to employees, and ensuring that there is no, discrimination or perceived discrimination. So that one, because you do need original I-9s, ICE is not going to like having copies of the I-9s. They will treat that in most situations as failure to have an I-9. So with that, if you have any additional questions, we would love for you to reach out to us. And we wish you a very happy holiday season and good luck with all your I-9s and I-9 compliance. Thank you, everybody.